Hi everyone. Thank you for the introduction. My name is Christina. I am a co-founder of Regularn. It's a compliance education platform. I'm also a compliance and risk management practitioner with over 10 years of experience, with a legal background and experience, especially in fintech. So let's start. Let me share my screen first and share the slides. So I hope you see them. If not, let me know. And yeah, today we're going to talk about the DORA. DORA is a hot topic for 2025 for sure. So let's start. Understanding of DORA. If for some reasons you still don't know what DORA is, so DORA, it's a European framework applied starting from this year to financial institutions, including crypto companies, and it sets a comprehensive set of rules for your information security and technology risk management, for management your third-party risk, for incident reporting, for information sharing and collaboration. And here you might think like all of the things are kind of familiar to you, are kind of exist on the market already, and you are correct. It's completely true, especially if you're already a licensed financial institution. You might meet at least some of these pillars in your practice, in your operation, but the thing with DORA is it makes it more formalized. It consolidates all the requirements under the same one unified umbrella, and it requires more evidence, more documentation from you. And another thing that stands out about the DORA is that it also implies huge comprehensive set of reporting obligations for the financial companies. And this is the part where all fintech struggles, especially. And yeah, why DORA matters for fintech. Here, I would like to encourage you to start thinking and looking at DORA not as a yet another compliance obligation, burden, constraint, a problem actually, but as a way to become better, to build a more resilient, more secure product, to provide a better service. Because actually what DORA does is that it provides a set of tools. Once implemented, they can really help you to become better. They can help you to uncover your weaknesses, to identify your gaps, to address them timely, to recover from the disruption, to be prepared in the face of disruption, to communicate better with your clients, with your regulators. And all of this actually gives a strong signal to your regulators, auditors, partners, maybe investors, that you treat your data and your security seriously. And this eventually will differentiate you from the other market participants and other market players who might be not that serious about the data, about the security, and about the resiliency of the product. Key deadlines you need to know. So basically DORA applied starting from January this year, and that means that as of January, from that point now on, you must be compliant already. So you must have all the processes in place, documents, you must start reporting your incidents, if any, you must start your resilience testing, and etc. And from the January, there would be different reporting deadlines. And the first one, for example, was back in April, so not so long ago, and a lot of firms really struggled, but submitted their first reports to their regulators. And for now, for example, in most of the countries, supporting documentations are not required and not requested, but you must keep in mind that even if you have submitted your report to your regulator in the forms of this information register, you must also have all the evidence, all the documents in place and be ready to provide them upon request to your regulators, because the details of the reporting process, of the reporting mechanism might differ and might depend on the country where you incorporated and where you regulated, but the overall, the essence, the overall process is still the same for all countries in EU. Another important thing about the DORA is the principle of proportionality. And what does it mean? DORA has a simplified regime, especially for the smaller companies. So if you're a startup company or early stage company, you might really benefit from it. And what does it mean? It means that the scope and scale of controls and effort and budget you put into compliance with DORA must be proportionate to the scale and complexity of your operations and your business model. So obviously, the bigger the company, maybe it's a big bank, the more mature and robust controls and processes and documents they would have in place. But if you're a smaller companies and just starting your operation, what does it mean for you? First of all, it's about tailoring your compliance by size and risks. So in practice, it's about starting from identifying your core services and your core business products, and then link them to critical technology, critical systems, critical vendors, and critical people that are needed to support these processes, to support these core services, and to deliver them to your clients. And start building your control framework, start building your documentation around that. And as you grow, the control will grow with you. Next, lean risk management. What we mean by that is that you should start from documenting your high-level approaches and let's say your overall risk management strategy and your vision of the risk management in your company. Later on, it anyway must be de-escalated and dropped down into the specific protocols and procedures for your employees. But setting the right tone from the top will really ease your compliance process, not even only with DORA, but overall in your practices. And also, the life hack here is that don't try to reinvent the wheel, most likely you already have at least something in place. You might have them either in the process of your licensing application, for example, if you're securing your license right now, or if you're already building your product, you might have some monitoring protocols and system in place. And what you can do, you can collect everything together, connect them, and try to adapt and adjust to DORA requirements. Don't write everything from scratch, and please don't jump straight away into this crazy 200 pages manuals, because it will make only confusion and not the right division of the responsibilities in your DORA compliance. Next, practical testing. Here, I would like to highlight that you should understand that testing, it's actually not a one-time exercise for your regulator. It's also for your regulator, but it's also for you. It can be really valuable and meaningful if it's structured properly. And if you're small companies, don't start with a big four audits, for example, right? Start with smaller quarterly vulnerability scans, or maybe tabletop exercise where you gather all your C-level teams, all your management teams, and go through modeled scenarios of a crisis. And by this, you can at least understand whether the team knows what is expected from each member. Do we have a plan in case of emergency? And if not, it's also okay. The next step, you can address every gap, every vulnerability with a precise response plan, and put everything on paper. And in case of a real emergency, you will at least have some framework. So the conclusion is that by calibrating your efforts, you can get the resilience you need and the compliance that will be proportionate to your team, to your particular situation, to your company, and to your product. Next, let's go through the DORA's main pillars. So first is the risk management. Here, regulators would like to understand and see how you actually identify your risks, how you assess them, how you mitigate them already, and what action plans do you have in place in order to become more resilient in the future, in order to withstand some disruption or some crisis. And yeah, apart from like meeting the regulatory expectations, it also gives you a day-to-day action plan and task list, what your team need to do actually in order to build the more resilient product. Next is the incident reporting part. Here, regulators expect you to report the serious incidents to them, to authorities, in their specified frameworks. And they are quite tight. So the first report should be submitted in 24 hours, for example. And in order to be able to do this, to meet this expectation, you first need to have a process internally of identification of the incidents or issues and reporting them to your regulators. Here, the collaboration is really important. I mean, the collaboration between your tech teams who are managing the technical part of the incident response and identification, and the compliance team who can help to understand the reporting obligation. Do you need to report anything at all? Or maybe you need to also report to some other authorities. For example, in case of a data breach, do you need to notify your GDPR authorities? And this collaboration will make this happen. Resilience testing, and I would also say business continuity and disaster recovery arrangements. We talked about the testing a bit earlier. On the previous slide, I talked about the tabletop exercise, but how actually all of this fits into the business continuity and disaster recovery. So business continuity, its ability of the firm to keep running and withstand a disruption. And the disaster recovery, its ability of the firm to recover after a disruption, restore all the data and all the systems in an acceptable time frame, right? So the testing, it's actually a practical validation tool, how you can test your plans and check whether they're actually workable. So by doing this and by modeling your test properly, you can understand whether the firm actually can keep operations running under the stress. You can model different variants of the stress scenarios with different levels of severity. Also, you can understand whether the roles and responsibilities are clearly defined and distributed among the teams, so teams actually understand what they need to do in case of a crisis. So, I mean, this can be really powerful tool, not for your regulator, but for you and for your operations. Next is third-party risk management. In fintech especially, many companies rely on other companies, and that's okay. We use vendors, we use even outsourcing of some parts of our services. And from one side, it allows a company to obtain the access to specialized expertise, which they might not have in-house. It also allows to grow and mature faster without growing the in-house resources and budgets. But from the other side, it triggers the third-party dependency because we actually don't have a clear day-to-day visibility over our vendors' operations, you know what I mean? And our sensitive data can be also exposed. So here, a regulator expect the companies to have a plan B, basically. They want to have, they want the firms to have a plan in case if a vendor fails. So do we have a backup vendor, for example? Do we have a communication flow in case of any incident? What the responsibilities of the parties when incident happens? Do we have, for example, clear exit clauses in our contract? So all of this is covered by the third-party management. And apart from just identifying risks associated with our vendors, the companies should perform like clear steps at the contract level to check whether they have all right clauses prescribed by our contract. So in case of an emergency, we can act, we can react, and we understand who is responsible for what. And for the due diligence for our vendors, have we done it yet? Are we satisfied with the trustworthiness of our partners, of our vendors? All of this is expected from a company. Last but not least, it's information sharing and collaboration. For now, it's optional, but you can join the threat intelligence group in your country or at the EU level and start sharing the information, start giving and receiving data, for example, for early warning indicators of something bad going on the market, or maybe of some threat, or maybe one firm became a victim of a cyber attack, and it can share the valuable insights and results of their investigation with other companies, so they can react in advance proactively to the same threats. And all of this is intended to collaboratively and together build a more secure and more stable and more robust financial market in general, in the face of our end users, of our customers, which are usually individuals, maybe corporate clients, whatever. But making the secure market, it's one of the main goals of the DORA. Practical steps to achieve DORA compliance. As easy as possible, start from the gap analysis. As I already mentioned, that you might have something, at least something in place. So leverage that you have, compare the existing documents, existing processes with the DORA requirements, and understand your gaps and understand your focus, what you need to prioritize in order to achieve DORA compliance. Another highlight here would be trying to adapt your current processes, especially for data collection, already into the DORA formats. What I mean by this? So I mentioned their reporting obligations, and they are quite strictly defined, and they have some specific formats. So if you already now start collecting your data, for example, about your vendors in the proper format, for example, DORA will require you to submit your dates, your agreement numbers, your currency, the governing law, the locations of your vendors. If you start collecting this information, when a deadline comes, you can just extract this data from your database and not going through each and every documents in the last night and trying to find all this relevant information. The next step, of course, can be the automation. In the perfect scenario, you can automate this data collection and link this to the your DORA reporting obligation. But again, in not all of the countries, it's possible for now. Next, prioritize quick wins, especially for smaller companies. You can really benefit from the templates for your incident reporting, for risk registers, for vendor registers. And you can maybe even look at some predefined scenarios, because there are really a lot of information on the market, and there are a lot of business models which kind of the same. So maybe you can benefit from what is already existent and already known. Next, what is important in terms of overall compliance with DORA? Document your rationale. Many firms really underestimate this, but having the document that would explain and justify, for example, why you chose this services as your core services, or why you decided that these systems are critical and these systems are not, why you applied these controls and why you think they are enough to mitigate this risk, and why you think this is your risks. Having this high-level explanation, high-level document will really help your regulator's life and your life easier as well, because hopefully in that case, regulator will not, or will question less of your processes and of your documents. Next, having evidences and having proper audit trails. It's important thing. And here I would like to highlight that DORA isn't a one-time exercise, it's actually a continuous effort. So you must be able to demonstrate this and must be able to prove this. So for this reason, you must collect and store all your risk assessment, update them timely and properly with having the, for example, relevant dates of updates, relevant people who were authorized to make these updates. It's also important to have all the test reports, action plans, action plan progress, also the board meetings, also important part of the DORA, because DORA also establishes rules for the governance. It means that your senior management team and your directors, who actually have the ultimate responsibilities for the resilience of your company, they must understand what is going on in your company and must make decisions towards risk management, and they must understand the risk the company facing. And in case regulator would ever question this, would ever asking about this, you must be able to prove it by showing, for example, the board meetings which were, I don't know, looked at some risks, some mitigation were proposed, for example, some responsible persons was identified, and some deadlines was put. And again, if you put in deadlines, don't forget to update them when the deadline is actually coming. Ongoing monitoring. Again, as I said, DORA isn't a one-time exercise. It's continuous exercise, continuous story. So you must also have the ongoing monitoring in place. And here we are talking again about the technical monitoring you have or you will have. And also, let's say this governance part of monitoring, but that's you can also call it a feedback loop. So all this risk assessment, all these tests are actually reported back to the senior management, to the board, and some feedback is received back to the teams. Common challenges and pitfalls for startups. Many companies have probably the same issues, especially at the start. First is the resources. They are limited and the budgets are limited. We all know about that. Next is compliance teams, which are overwhelmed, which are overloaded with compliance tasks. And also startups usually have the limited bargaining power when we are talking with our partners or our investors or maybe our vendors. And again, to overcome this, it doesn't happen overnight. It's continuous effort, the same as the DORA compliance is continuous efforts as well. And try start from, reframing your compliance process, reframing your compliance thinking, if we can say like that, and try to link your compliance processes with the business processes as much as possible. For example, you can drop down the bigger compliance exercise into the smaller ones and link them into your production sprints, for example. You can link your compliance deliverables with your strategic goals like market expansion, access, building trust, securing new revenues, for example. And then we can look at the compliance and it starts feeling like a growth enabler rather than obstacle, And with vendors and partners and investors, again, trying to negotiate the proportionality principle and agree on some common sense scenario and don't go under the huge strict audits unless you are not ready, and agree maybe to start with the external third-party audits in 1 to 3 years once you are ready. Okay, it seems like it's all from my side, and it also seems like we are on time. So it's time for questions if we have some. Okay, it seems like we have something in here. Let me check the chat. Okay, we got the question regarding the PDF. It was answered. The recording will be shared as well. What is the price of the mistake if you have an incident you are not compliant? It's a really good question. As far as I am aware, again, if we compare, for example, with GDPR framework, right? It has a concrete numbers and concrete price, let's say, of the non-compliance. DORA works in a different way, and I believe, it's case-by-case situation. If just one incident and for some reason you didn't report it, a regulator will look at it, will understand why. We'll look at your, again, remediation plan and how you also plan to remediate this failure of not reporting. And if it's just this one case, I really don't think regulator will impose a penalty to you, et cetera, But what it can be, not reporting the incident may trigger a bigger investigation and a bigger interest from your regulator to you, because it may evidence that maybe your processes are not good, maybe your reporting mechanism is not working. Why is that? Should we look at this firm more closely? And if they will look, and if they will find a bigger picture problem, there might be penalties. But again, the regulation just entered into force. As far as I'm aware, there are no enforcement yet. So we'll see how big is the price soon, I believe. Hopefully will not, but everything can happen. So
Yeah. Hi. There's questions in the Q&A section.
yeah, I also see another one, right? Who is responsible for handling DORA compliance? It's a matrix of so many functions inside the company. For example, audit trails for modifications, authorizations, who is that's a really good question, because you are correct that this is a collaboration between the different risk owners, right? And in different companies, it might be structured in different ways. For example, for vendor management, usually legal team is responsible, right? For incident reporting and incident response, it's CTO or CISO, whatever, the tech teams. For communication with clients, because it's also a part of the incident response. If we have a bigger problems, it might be client managers involved. It's really a great scope of the people who might have their responsibilities and roles in this overall project. In, let's say, a bit bigger firms, it's really beneficial to have a one assigned risk manager who is responsible for managing the DORA compliance or the similar framework. It might be UK operational resiliency in UK, for example. It might be something else. And the role of this person, it might be also a compliance officer if you are not that sophisticated for now. But the role of this person is a coordination, because we all understand that a compliance officer might not be aware and might not have an relevant expertise in some very technical things, but it might be responsible for coordinating the efforts, collecting all the information for all people involved, synchronize the process, track the progress, and for example, have final deliverable in form of the report to your regulator. It's one way to do this. If you don't have a compliance team in-house, for example, for now, I usually see it's a COO who is responsible for the operational part of your business. And basically, COO is usually responsible for the resiliency of the product and for the delivery of the product. So this DORA obligation might also fall under this person. But again, in this coordinating role and facilitating role, because the role of CO would be to, again, collect everyone together, make sure everyone understand their part, they deliver their part, again, collect everything back and report, for example, to your regulator. So there might be different options, but I would say there are no, single responsible person. It's a real teamwork and it's a real collaboration. Victor, please help me, because I see only two questions for now.
Okay.
And if there's something I missed, yeah.
Yeah. Let me just copy paste them to you.
Yeah,
Uh,
please. Maybe it was sent privately.
Yeah, so these are questions from Prasad, uh, and I'm going to paste two questions from Prasad, and then one from Thomas Richter. So that's those two are from Prasad, and then this third one is from Thomas.
Mm-hmm.
All right, can
Okay,
you
let's
see?
start with the last one. Does DORA apply to crypto service providers? If yes, to that extent, and what does it apply only to those who operate under MiCA? Okay, I got the question. That's a good question because you are correct. The DORA states that it is applied to the crypto service providers regulated by Market and Financial Asset Directive. So I understand that in the way that once your license, your VASP license, for example, right, or your MSB license, whatever, will be, let's say, exchange, or will once you will receive your MiCA license, from that point, the DORA applies to you. But again, I believe in process of the license application, regulator might also look at the DORA arrangement. Yes, at that point, you will not have the reporting obligation, but the framework, the documents, the processes, you probably might already have in place. So hope I answered your question. Next, does the Liechtenstein Foundation's EEA status alone trigger DORA obligation if the token related operations are technically executed from the US? If our legal structure for Liechtenstein Foundation and the actual token many deployment occurs the US-based entity, especially eventually intended to serve. Okay, it's a bit in-depth question. I will answer right now very high level my thought, but afterwards I can check and probably we can contact you or publish our answer somewhere else so you can read the fuller version. So DORA actually states and that it's applied to the companies that are regulated if they're in the EU. And considering that DORA also implies a lot of the reporting obligations, which are very linked to the particular regulator. For now, I believe there is a real gap if a company is established outside of the EU, for example, in the US, and service clients in the EU. Maybe later they will introduce some registration requirements. For example, if you're not licensing in the EU, but want to accept and provide the services in the EU, maybe you will need to register your non-EU company, or maybe they will require you to set up some representative office in the EU in some country, and then you will kind of fall under the regulatory perimeter of a particular country. But that's a really good question. Let me check. I'm also got interested right now, and we will get back to you. I believe they are both kind of familiar, and we can check them afterwards and reply to you.
Okay, I think that's all the questions. I don't know if anyone else has any um questions. Okay, the follow-up question.
The follow-up question.
He said, does the licensing foundation EA status alone trigger DORA obligations, even if the token?
Yeah, I said that I
Yeah,
will
she's going.
combine these questions in one and check them, and then we can get back to you. I just had my high-level thoughts, but I'm not sure right now.
All right, Prasad. We're going to be getting back to you, and so please, we'll be in touch. Your email, we have access to your email by you registering for the webinar. So please, we're going to be wrapping up now. Do we have any other questions before we end the session here? Please keep your eye out on your inbox. Okay, Prasad, you said you emailed but no reply. Yeah, we'll check and get back to you. Please keep your eye out on your inbox. We'll be sending the webinar recordings. DORA compliance checklist and the slides. And then for those of you like Prasad who have detailed questions, we definitely will be sending you responses shortly. So yeah, thank you everyone for taking out time from your busy days to join the discussion. Please feel free to follow Legal Notes on LinkedIn and on Twitter. We definitely would be hosting more sessions on this discussion. So keep your eyes peeled for those updates. And yeah, thank you, Christina, for taking out time to speak to all of us. And yeah, thank you so much. You could reach out
Thank
to
you,
me
guys.
Victor.o at Legal News. I'm putting that in the chat now. Um, Let me put that in the chat. So to everyone, great. So yeah, thank you all for joining.
Thank you. Thank you,
Yeah,
guys.
enjoy the
Bye-bye.
rest of your day. Bye.